Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Harvey L. J., Chief Judge presiding. All persons having business before this court draw near, give attention, and will be heard. In God save the United States of America, the State of Florida, this honorable court. Please be seated.
Good afternoon. We're here for our second oral argument of the afternoon. Our first one was by Zoom. I'm Harvey J. I'm presiding. Today I have the honor and privilege to have two very experienced colleagues. Judge Makar to my right. He and I served for a long time in Tallahassee on the first DCA. Judge Makar before that served on the first, and before that was Solicitor General of the state of Florida. So a very storied past, a very noble past there. And to my left, Judge Lambert. We all know Judge Lambert to be a longtime member of the 5th DCA, and before that, a longtime trial judge, and before that, a board certified trial lawyer in Ocala, Florida. So I feel like the odd man out of this very august panel today. Please be mindful that we're here today in part, large part, to ask you questions, because if we could just get by without us asking questions, we could have read the briefs and the record. So please do your best to answer our questions, to answer them in a way that gives us answers. I know that's sometimes hard. I know you're here as advocates, but also be mindful of the fact that we are concerned about what we're concerned about. Also, just for the benefit, I'm not sure we're having a recording right now, but the marshal says we are. So it is being recorded. If you would be kind enough to make sure that any cell phones have been turned off, so we don't have that uncomfortable moment when a cell phone goes off during the proceeding. But without further ado, Ms. Robinson, if you're ready, you may proceed. And once you get to the podium, you can let me know if you would like to reserve any time for rebuttal.
Good afternoon, everyone, and I will reserve 5 minutes for rebuttal. And may it please the court.
Please proceed.
My name is Crystal Robinson, and I'm here on behalf of the appellant, plaintiff in the case below, Ms. Tamar Beeman. And we're here on a final judgment that was entered on May 29 of 2024, where we believe the trial court committed fundamental error because it deprived my client of her right to present her case as to count 3 of her complaint, which was seeking monetary relief relative to a breach of contract of coverage C benefits under her all-risk insurance policy.
So, and I know that's one of your arguments, count 3 being something that your client would still be entitled to advance. I went back and read the motion for summary judgment, and I saw it was asking for relief on everything. Did I misread the motion for summary?
I believe you're referring to defendant's motion or appellee's motion.
And thank you for that clarification. Yes, the Security First Insurance Company motion for summary judgment, as I saw their prayer for relief actually twice, they were asking for a complete summary judgment on all claims. So if, in fact, the court granted a complete summary judgment on all claims, how was there a deficiency as to count 3?
So there was not a request for relief of all claims, specifically the motion, and if I may grab the record just so I can
certainly,
point you to the
and
site.
I think I have it as well.
So the defendant, appellee's motion for summary judgment asked for, and this is on page 3.
I see page 3 of the motion.
I'm sorry, I'm trying to point you to the specific page in their motion where they identify the specific relief sought. But while I'm pulling that up, Judge, Your Honor, they were asking specifically for a ruling, which is why it was a cross motion, a ruling on the interpretation that was framed in count one. They believed that if they prevailed on the ruling or the interpretation, that it would be dispositive of the issue raised in count three, which we disagree with. The motion for summary judgment that they filed, they asked for relief found on page,
Well, and why don't I direct you and you tell me why I'm wrong?
Okay.
Page 6, I see a synopsis at paragraph 15, and if you go to sub 4 of paragraph 15 on page 6, it says, "In defendant's denial of coverage is appropriate pursuant to the plain language of the policy." That would seem to this judge to be pretty complete, but how is that not, and there's an and, how is that not everything?
so because the title of the motion, I think, is really just a misnomer in this situation here, because when you go through the arguments that were addressed throughout the motion itself, including even at oral arguments, all of the relief that was addressed was directly addressed at coverage A alone, including the arguments that were contained in the motion itself. But I do want to mention.
And let me stop you there, and I will mention one other place. Page 18, sub 5, it says, "As a result of the foregoing, defendant is entitled to summary judgment as a matter of law, and plaintiff shall take nothing in this action." That's page 18. But did this argument get raised at the summary judgment hearing, saying that the summary judgment motion by Security First Insurance Company didn't reference count 3?
Your Honor, we didn't raise that because we had no reason to believe this would be entered as a final judgment as opposed to an interlocutory. We did raise it, however, in our motion for relief, where we asked the court to, there were two things actually, and that will bring me to the next point that I was.
Well, and when you say motion for relief, you're talking about your motion for rehearing?
There were two separate motions. So initially, just by way of background, when the order for summary judgment was entered, which was October 2 of 2023, or pardon me, the hearing was October 2 of 2023, and then we had an order that was rendered on October 19. We actually did file a motion for rehearing on October 21, and then after the order was entered, we appealed. Because we appealed, the trial court would have been divested of jurisdiction, so we could do nothing else in the trial court. Defendant at that point moved to dismiss, arguing that it was untimely because the date of the order said October 4, and it reflected as October 4 on the docket. The court did indicate, including in the now order that we're before the court on, that the order was in fact rendered on October 19 or 20 and not October 4 as shown on the docket. So there was a timely motion for rehearing first under 1.530, and
And maybe I've missed this part of the record, but my understanding of our dismissal of the appeal is that the motion for rehearing was not timely, and therefore the appeal was dismissed because it didn't properly told the time. Did I miss that in the record?
Yes, Your Honor. So Judge Orfiger actually took the time to clarify that in the.
I missed that, but that was not the reason for the Fifth DCA's, this appeal was dismissed.
Yes, Your Honor, and we did raise that argument in our jurisdictional brief, but the court still dismissed without any discussion of the reason.
So that's dispositive, is it not? That's over. If we dismiss the appeal, your argument that you filed a timely motion for rehearing has now left us. I don't know how else to deal with that if a panel of this court said it was untimely. I can't reconcile it otherwise, respectfully.
I understand, Judge.
Let me. You appealed here. It was dismissed because the chronology, the motion for rehearing appeared to be untimely and didn't toll the time for you to file a notice of appeal. So it was dismissed up here for being untimely. You then filed a 1540 motion, didn't you?
Yes, Your Honor.
And Judge Orfinger granted that relief to the extent that he said, well, basically, the clerk didn't send you the actual final judgment. Therefore, you didn't have that first period of time in which to do something. But the concern that I have is when the judgment was re-entered by Judge Orfinger later, which is what you're appealing now, you did not then file a motion for rehearing pertaining to that reissued judgment, even though I think Judge Orfinger's judgment said you can now pursue the appeal or a motion for rehearing. And so whatever you argued before on the motion for rehearing seemingly isn't appearing in front of us now as preserved, whatever was preserved in that motion, if it was preserved.
So-
Isn't that kind of the chronology? I was talking a lot about chronology this afternoon, but isn't that the
Yes and
chronology?
no. So yes and no. So first, as it relates to the right to move for rehearing after the 5/29/2024 re-enter judgment, Judge Orfinger did actually say that he doesn't want us to come back. And I noticed that in defendant's response brief, reply brief, they basically said that that was something that Judge Orfinger said. But there is no citation to the record. In
When you
fact,
said he said it, you mean he talked to you all about that?
oral
But it's-
pronouncement.
But it's not, I mean, he doesn't have the ability to say you can't move for rehearing if he's reissuing something.
Your Honor, because his position at the time was, and is that he had already heard all the same arguments, and so this was really just to preserve or appellate rights because of the dismissal that was entered in this case. But separately, Your Honor, our position is regardless of whatever that outcome was, even if this court were to find that there was no timely motion for rehearing, our position would still be appropriately raised for the first time on appeal under 1.53. 1.530 is simply to request rehearing, or you can go straight to the appellate court for relief if there is entry of, to correct the substance of an order that was entered. Here, there was entry of a final judgment with litigation of only one count of my client's complaint. And we had asked the court to consider the affidavit of our engineer, Cesar Hernandez, which would have called into question whether the sewage backup exclusion was even applicable to the facts of this case.
Again, I want to make sure I'm understanding, Mr. Robinson, but that affidavit, we can't see, can we? I mean, if the motion for rehearing was untimely, and I know you disagree with that, but that appeal was dismissed, a motion for rehearing was not filed to the re-entered judgment under 1540, and here today, that motion that you filed doesn't appear in this record, does it? As a practical matter, just given the sequence of events that have led us here, including the affidavit?
The affidavit of Cesar Hernandez is not necessary to obtain the relief that we're asking, Your Honor, because the fact is that my client has the due process right, or the right to state her claim and make arguments, present her case for breach. And there was a pending breach count at the time that there was entry of a final judgment. The entry of final judgment should really have been interlocutory at best, and then allowed my client to present whatever evidence would have been available to make a claim or state a cause of action for
So are you
breach.
saying so you're saying when Security First was arguing their summary judgment motion, they told the judge that this only pertains to certain causes of action and not this other cause of action you're talking about?
That is quite literally how the arguments read. If you read
That's what came out of the lawyer's mouth for Security First.
Your Honor, they would have said specifically that this relates to the dwelling. They were arguing the entire time dwelling. I actually believe that was simply just oversight by counsel, to be honest, or even with the judge. We were not moving, so our motion at the time that we filed it was limited to count one, and it says that even in the title. It was motion for summary judgment as to count one.
Your motion.
Correct. And they
But-
filed a cross motion and addressed only the merits of our arguments in count one.
But would a partial summary judgment have been appealable?
No, Your Honor, and this is part of why we're saying, so part of the relief that we're asking for today, it's twofold.
But there was a dismissal of the appeal because it was untimely. So I'm trying to reconcile these two paths. So there was an appeal taken that was dismissed, that we have to deal with, right or wrong, good or
Right.
bad. So isn't that indicative that at some level, you or someone on your behalf believed you had a final order?
Your Honor, it was entered as a final order, so the only recourse available to my client at that point is an appeal or a 1.530 motion because it's entered as a final judgment.
You agree it was entered as a final judgment?
Correct, yes. And when, at the time, and I'll clarify this as well, at the time that we sought relief under 1.540, we did so believing that it was a mistake by Judge Orfinger to enter it as a final rather than interlocutory. We were arguing that it was oversight, essentially. Judge Orfinger clarified that wrong or right, it was his intention to enter it as a final judgment, and therefore the correct relief would have been to do either a 1.530 motion or an appeal. We elected to go forward with an appeal.
So he then clarifies it. So why not move for rehearing as to that clarification as to the 1540 judgment?
Because we had the option to also bring a motion, bring an appeal on the issue. And at the time that our appeal was filed, again, traveling under the 529-2024 motion, assuming nothing else had transpired, once there was entry of a final judgment without any litigation of count 3 for breach of contract, litigating only count 1, it was appropriate to bring a notice of appeal because it really should have never been entered as a final judgment. That was judicial error. And it was judicial error, it was fundamental error specifically because my client has the right to state a case for breach under coverage C. And we've never been given that opportunity to litigate.
I certainly want to hear you on this, Ms. Robinson, but I gave you 2 places in this motion where they've asked for a complete summary judgment. Judge Orfinger enters a complete summary judgment. So how is there some infirmity there?
So there, if you go back to the order, Your Honor, and I'll point you to the language. The Judge Orfinger, let me backtrack. First, as it relates to the burden, defendant is moving for summary judgment in the case below. Even assuming that they meant to do so, they would still have to provide evidence of cause. As of today, all that we know or all that's agreed is that there was some reverse water flow into the property. There is no discussion, no evidence of water having been the sewage overflow or sewage reverse flow, being caused by a break in the sewer line or anything to that effect. All they've simply said is that there was a backup and assumed the truth of the matter, that there was a backup that we all agreed as to what backup meant, essentially. That is all that's presented. There is no evidence. We've never been able to depose the engineer, for example. So you will see in our opposition to their summary judgment, we actually opposed their assertion that the loss was caused by sewage backup. That was we objected on that basis. We've never agreed, and Judge Orfinger's order does actually say that it's undisputed that the loss is caused by sewage backup, but in fact, that is not correct. We objected to it, and we said that the only evidence that's been provided by the defendant is evidence of water entering the home because of water overflowing from her toilet and migrating throughout the home.
So the sewage that was backed up into your client's home from the lift station across the street, you're saying that's not factually accurate? The sewage didn't come from the lift station's explosion or whatever?
I apologize. We agree that water did enter my client's property from across the street. However, there is an
Or
opportunity.
sewage?
Pardon me?
Sewage, wasn't it sewage?
Yes. Well, it would have been, regardless of whether it was how the exclusion that was used, whether water or sewage. The question was there water entering my client's home because of the reverse flow of water? And so part of why we had brought this declaratory relief action is because our position was this is not the type of loss that we believe the exclusion was meant to apply to.
Your client got a settlement or got some kind of check written for remediation from the utility?
Yes, and that goes to my point. It is not in dispute that the source is the lift station. That is undisputed. It is undisputed that it is off the residence premises. Now, in order for even the limited water damage coverage and therefore the water damage exclusion to apply, it needs to be that there was sudden and accidental direct physical loss. My client has coverage for contents simply with direct physical loss. The exclusions that you see in the limited water damage endorsement coverage, and then the related water damage exclusion, those only relate to sudden and accidental. There is coverage for simply just direct physical loss. And there is an express grant of coverage for loss caused by sewage migration. So if my client had been given an opportunity to bring her case in count 3 for breach, we would have been able to present evidence that the loss that she suffered is entirely outside of the exclusion that was used to bar coverage. As of today, and that would have included, for example, deposing the engineer to determine, was it in fact a break in the line as counsel has stated? Because even though they've stated that in their briefs, nothing in the engineer's report says that. The engineer's report says plainly that it was simply an improper repair or replacement. We've never been given an opportunity to determine if that was in fact the cause of the water leaving from the sewage station entering my client's home. And that would have been the thing that affects the existence of coverage here. And we also note, Your Honors, that the evening counsel's answer brief, you'll see that each reference to blockage to sewage backup that they have referred to, it's contemplating some type of block in the line or break in the line, which is exactly how my client would have understood that the exclusion will apply, a sewage backup applies to instances of some type of failure of the line itself, which is separate and distinct from if there's simply just a reverse flow of water. So there's nothing wrong with the system, it's just a pressure issue. That is essentially what our engineer would have stated. And we would have been given an opportunity to develop that fact more and allow discovery on that point, and also take our own testimony of their engineer had we been given an opportunity to litigate count 3. But as of today, we've simply just not been given that chance. And our position is, even if, and this I guess is the crux of the matter, even if it is true that the sewage backup exclusion is unambiguous and does in fact apply to the nature of loss that my client had sustained, what is still true is that my client has the right to state her claim and present evidence in support of her position for count 3, which is breach, because dwelling is insured on an all-risk basis, whereas contents is insured on a named perils basis. There are different factors and burden allocations that are used for the two categories of coverage, and count 1 for declaratory judgment says plainly it is directed to the first count of our complaint, and it is limited to coverage A alone. Count 3 is the only count in the complaint that is directed to benefits for coverage C. And it is also the only time that we have asked for monetary relief. Before that, everything else was purely contract interpretation. So regardless, as I mentioned, of how the court rules on, breach versus no breach or deck versus no deck, we have a right to bring count 3, and we've never been given that chance. And that's fundamental error.
Thank you, Ms. Robinson, and you have gone through your rebuttal time. So we will now hear from the attorney for Security First.
May it please the court. Good afternoon. Mark Tinker on behalf of Security First Insurance Company. I'd like to start with what counsel finished with and what kind of went throughout the entire argument is that they've never been given the opportunity to litigate count 3. That's incorrect. I think the record shows otherwise. Security First motion for summary judgment, Judge Jay, as you cited a couple of times, asked for judgment on all counts, and that is because what was litigated is the limited water damage coverage and water damage coverage exclusion endorsement. That is an endorsement that applies an exclusion to the Section 1 coverages. That's all coverages. That includes coverage A to the dwelling and coverage C for contents, which was what count 3 was asking to litigate. So by Judge Orfinger finding this endorsement and this exclusion applicable to the case, that applies to all counts in the complaint, and that is why he had properly entered a final judgment. The other thing that I know that was discussed a little bit is the timing, and a lot of the arguments that were made are based on the motion for rehearing. There's discussion of the affidavit that was attached to the motion for rehearing, and you're correct that that is not properly before this court. What occurred is the judge entered the original judgment, 17 days later, Beeman moved for a rehearing.
And that's when that affidavit was attached?
Correct.
So, I mean, it was plenty of time that could have been presented as summary judgment evidence in opposition, but never was?
Correct. It was an expert engineer that Beeman retained, so that was someone that she could have retained months, years before. I believe the motion was pending for about 9 months before it was actually called up for hearing. So that is something that could have been presented before. It wasn't presented as newly discovered evidence or something like that. It was presented in response to the judge's decision. It was an attempt to get around the judge's ruling as a part of the rehearing. But again, the motion for rehearing was filed 17 days after the judgment was entered. The notice of appeal was filed, I believe it was 57 days later, which is why this court dismissed it as untimely. When we went back to the trial court, the reason that the motion for rehearing was filed late is because the clerk, for whatever reason, didn't serve anyone with the judgment when it was originally entered. So it was rendered, it was filed with the clerk, it was docketed, was actually rendered, but never served on anyone. So the judge, upon learning that, said, I'm going to enter a new judgment so that you have a new time to either seek rehearing or appeal.
Is that what happens nowadays in trial courts? I mean, I'm, Judge Jay said that back in the last century, I was a trial judge. We used to send the JA or me would send it out. We'd mail them out. We wouldn't give them to the clerk to mail out. I'm just curious if that's what's going on in the world of circuit courts nowadays, that
Not sure.
the judge enters something and he sends it downstairs, and whenever the clerk gets around to it or something. Is that how it's working?
From what I've seen, they're all done differently. It depends on the
Okay,
judge.
I'm just curious.
There's nothing in the record that says what happened with this one. We just know that nobody received it.
Okay.
Counsel, if I could ask a quick question. Is sewage backup from a lift station, or wherever this was, a utility station across the street from the house, is that type of risk ever a covered risk under any of your policies?
Under the main policy, I believe it would have been covered. Under this endorsement, it is
Okay,
not.
so the original unmodified policy would cover it?
I mean, I haven't done that analysis because we have this endorsement in place, so I was looking at
Well, I
that.
know the endorsement may take it out of the picture, saying that it says, I think it says, sewage that backs up through sewers or drains is excluded.
The normal Section 1 exclusion for water damage does not discuss water or sewage that backs up through drains. Actually, no, it does. I apologize. Subsection C2 does exclude coverage for water which backs up through sewers or drains or which overflows from a sump.
So under no version of the policy, the endorsements, whatever, that risk is never covered?
No, Your Honor. It does not appear it is. It's
I
an
guess it's an
excluded
all-risk policy except that risk.
It is excluded by the regular water damage exclusion, and then, of course, this policy was modified by the endorsement, and it is excluded there as well.
Does your client ever offer a policy that offers coverage for the risk of sewage backing up from a sewage lift station across the street?
I don't know the answer to that question, Your Honor.
Just asking. Thank you.
The only other discussion that council mentioned was that there was never actually any proof that there was a backup here, and what was cited in our briefs is actually Tamara Beeman's own testimony of the backup. It's on pages 483 and 84 of the record. She described exactly what happened, and she described sewage backing up through her tub, through her sinks.
Well, I mean, wasn't the discussion at the trial court, and Judge Orfinger seemed to be puzzled about the nuances, that didn't your opponent agree it was a backup, it just wasn't an overflow?
That was the
Or
argument that was
something like
made,
that?
yes, is that a backup occurred, but that somehow an overflow and a migration should be treated differently.
And he was saying you can't have an overflow unless you first have a backup.
Correct. And I think his quote was that an overflow is a backup that really, really backs up. It just keeps backing up until it overflows, but it's still a backup.
And regardless, you had an anti-concurring clause.
Correct.
So even if there is a distinction or the difference between the two, because the backup is a conceded, if I understood the opposing counsel at that hearing, was conceded that that was not a covered event under the policy with the endorsements, that anti-concurring clause would moot that discussion, as interestingly academic to Judge Orfinger as it was, wouldn't it?
Yes, it would, Your Honor.
Okay. And as to the expert's affidavit, I mean, part of your brief is that The affidavit essentially said, in my opinion, this is a covered event, and that's really a question of law for the court to interpret?
Yes, and the expert also tried to define what is the difference between a backup and a backflow in expert engineering parlance, and of course, that's not the test that the court applies when it's looking at policies, that it's a plain language analysis, or as this court has phrased it, it is how it's understood by the man on the street, not by an expert engineer trying to tell us what different terms should mean in engineering world. So, and again, but the affidavit was attached to the motion for rehearing that was never properly ruled upon, so it's not even before the court.
And if maybe I misheard Ms. Robinson's argument, during the summary judgment hearing, your side actually did say we're asking for a judgment on all counts.
Yes.
It wasn't just we're limited down to the coverage A, or I guess coverage A under your policy, it was
all counts, because again, this is...
all counts, whole thing.
Because this is a Section 1 exclusion, it applies to all coverages under Section 1, including coverage A and coverage C.
Okay.
Unless the court has any other questions, we just ask that you affirm.
Thank you, Mr. Tinker.
Thank you.
There's nothing more from the court. That being our last oral argument of today, we're now in recess.
All rise.